5 days. You've been expecting this episode for 5 days. You knew it was coming Wednesday, right? I mean, we're buddies. You knew I was going to follow through. But then it didn't happen. I could tell you a tragic tale of sickness and unfortunate circumstances, or I could tell you I just didn't feel like it. Maybe I did it to prove a point. The thing is, it doesn't matter what truth I tell, because the larger picture, the late episode, affects so many more people than whatever my issue was. Do my intentions make the fact that you didn't get an episode on time more or less fair? The point I'm trying to make is in the larger picture, it's not about a person's blameability. It's about the mass effect it has on everyone. Like, say, if a justice system cheats. Some people don't like it when I talk about myself. Some people want an explanation. I gave one. It's in the Facebook group. You can find it there if you're interested. Previously on Convicted. And with all the instructions that a jury receives and all the training and experience that attorneys and eventual judges have, can biases be eliminated or even just pushed aside? I'm human too, and to deliver a story without any bias, I believe would be next to impossible. But I must tell you, as the story progressed, and as I accrued more information, my emotions have been on a roller coaster. But my opinion on the injustice of this conviction has not wavered. I made a bold statement in the first episode, and pretty much every episode after that. Richard Nicolas did not get a fair trial. This episode is where the rubber meets the road. This is the one where I tell you what compelled me to make this podcast. I'm Brooke, and oh wait, I need to play a disclaimer first.
This podcast contains bias. The aforementioned bias isn't in reference to innocence or guilt. It's biased against members of the justice system who cheat to win. It is a fact that all people deserve a fair trial. Listen at your own risk.
I'm Brooke. This is episode 7 of Convicted. I've gotten a lot of questions this week. It felt like all the listeners simultaneously realized. Richard said they had popcorn at the movie. Couldn't they tell that at the autopsy? You know, they probably could tell something like that, but the jury didn't hear it. Hundreds of listeners thought to ask, but 3 attorneys didn't. I have a great new sponsor. It's called Chatbooks, and I'm in love. Chatbooks creates photo books from your Instagram, Facebook, or camera roll. Or you can mix and match with multiple contributors. Every 60 photos that you post or choose are automatically printed, including the captions, dates, and locations. Then it's sent to US users for free. It's 1 picture per page. Simple, but classic. You can choose hard or soft cover. And you can choose 6x6 or 8x8. All 60 pages are only $8. And you're guaranteed to love it or your money back. Trust me, they're beautiful. So go to chatbooks.com/podcast to download the Chatbooks app and get your first series book for free with the promo code CONVICTED. Chatbooks.com/podcast with the promo code CONVICTED. You're really going to love it. Let's talk about the medical examiner. Dr. Dennis Chute, Chute, worked at the office of the chief medical examiner at the time of Asia's murder. According to his testimony, his job was to perform autopsies, investigate the cause of death and manner of death in medical legal cases that get referred to his office. He graduated from the University of Notre Dame and then Harmon Medical School in Philadelphia. He was a board-certified forensic pathologist and also board-certified in anatomic pathology. In his time as a medical examiner, he guessed he'd completed over 1,000 autopsies. His resume qualified him as an expert to testify in this case. I gave the gist of his testimony last time, but today we're going to focus on the autopsy. More specifically, lividity and stomach contents. Lividity is when a person's blood settles when they die because of gravity. If a person's on their side, it would settle on their side. If they were on their back, it would settle on their back. Basically, it settles at the lowest point. When lividity is said to be fixed, it means that when someone touches or otherwise applies pressure to that area, it doesn't change. For example, press on your arm with your finger for 30 seconds. When you lift up your finger, you see that spot is more pale than the rest of your skin tone. It's because you don't have fixed lividity. Lividity starts to occur at 2 or more hours, and it usually takes 8 to 12 hours for it to completely fix. I got that information from Dr. Schute's testimony, but I confirmed it with a source on the list. Let's stipulate that's true. In the transcript, Sharon May asked this question. Bear with me, it's a little long. Dr. Schute, if this victim was found slumped towards her left side in the vehicle, and the victim was taken out of the vehicle at some point and laid on her back where she remained for the next, say, 13 and a half hours until the autopsy started, based on a reasonable degree of medical certainty, how long was the victim leaning towards her left side before she was placed on her back such that lividity showed up? Dr. Schute says 2. 2 or more hours. I want to make a clarification here, though. The question was a hypothetical. If the victim was on her side in the car and then on her back for the next 13 hours, then what? There is absolutely no evidence, records, or documentation about what happened to Aisha's body after it was transported from the crime scene. Let's talk about his answer. His answer to this hypothetical question that after 2 hours on her side in the car and then 13 on her back, lividity would have fixed on her side. Remember what he said before? That lividity doesn't fix for 8 to 12 hours? I'm not great at math, but that doesn't add up to me. I wondered how the defense dealt with lividity, so I asked Howard Cardin when I met with him. Oh, and a side note, according to the transcripts, Christina Gutierrez had a family emergency and wasn't around for the days that Dr. Schute testified.
The lividity issue as an issue did not come up right away. It was just something that was buried in the medical report. When we learned that it was going to be a major issue, Christina grabbed on it. She indicated that she had access to the expert medical issues and we could get it resolved. But we never really got that far. And that's probably, and I think I told you, that's probably the one part of the case that concerned me. I tried to do what I could with it, but, you know.
So I have an affidavit from you saying that after the lividity issues came out that you consulted a couple of doctors. But I also have a transcript from a post-conviction hearing from Arthur saying that you called an expert and he said that it wasn't that big a deal or something like that. So I just wondered, who did you consult? Because I would like to talk to him.
Oh, on the lividity issue? I just did it in general terms, one of whom was my son, who's a pediatrician. And then we did call, and Art may know it, I forgot who we made contact with. Went over it with them. And I think that's when Christina was still...
She had like a family emergency or something.
Yeah, and...
He consulted with his son, who is a doctor, and some other expert that I've never gotten a name for. He suggested I asked Arthur. So I did.
I remember when we left the courtroom after the doctor testified, I asked Howard. Howard said that he had a friend who was a doctor, an expert, and he would check with his associate, the doctor. And he came back and he said that he couldn't do anything. The doctor said he couldn't do anything.
I'm not trying to trip anyone up. The 90s were a long time ago. I think it's fair to say that they didn't have a grasp on the importance that this issue would have in the trial. And it is a fact that they didn't have an expert testify.
When the lividity issue came up, we huddled as we always did. My office was not here at the time. My office was up the street. I was here before it and afterwards. Art was right around the corner, also in a private kind of office. And I forgot which place it was that we huddled. Christina would meet with us as to how we were going to resolve this issue, because each issue that came up, we had some kind of game plan. And the first thing we said was, we need to find out about this. How realistic is what they are saying, that the blood's going to flow down and coagulate or solidify. And so I said, I'm going to talk to my son that was a resident, chief resident at University of Pennsylvania Hospital, CHOP. And when I spoke with him, he had a couple of others that were with him. And we talked about the lividity issue as not being a yes or no kind of thing. Yeah, the blood tends to fall, gravity brings it down, it tends to thicken, that kind of thing. But it's not something that is so dynamic. And then we spoke to whoever that person was, and the person made about the same comment. So when you say it's not such a big thing, I don't think it's not such a big thing. It's that it's just not one of those things that's capable of being 100%.
Dr. Carden, Howard's son, was right. Lividity by itself is not an accurate way to determine time of death. Even a forensic pathologist cannot accurately determine a time of death based solely on lividity. The frustrating part of that for me, when Howard said those words, was, why didn't anyone ask him that? Why did the jury never hear that? Did the prosecution misrepresent it? Absolutely. Did the defense call them on it? No. Okay, think back to that night for me. Officer Hannah and Richard return to Asia together. Officer Hannah orders the girl to be removed from the car contrary to protocol. That's fact, not bias. She's taken out of the car and placed on the ground. Now, I'm going to share with you a letter. This letter is one of the documents I was holding when I decided I was going to tell this story.
Dear Officer Hannah, thank you for everything that you did before, during, and after this trial. We really did appreciate your case preparation and your faithful attendance each day. Since this case was the first time that you ever testified in court, we thought that you might like to have a copy of your testimony for posterity. This way your wife can see how well you did. Rumor has it that you were given a hard time about removing Asia's body from the car. The basic rule is that you should not disturb the crime scene. We think that the basic rule is a good one and should be followed. However, the reason that you did in this case is certainly understandable. We knew from the very first interview with you that you were overcome with concern the instant that you saw Asia. Your feelings were so markedly different from those of the defendant. We want you to know that although moving her was not standard procedure, it turned out to be the right thing to do. Had you left her in the car, we would never have won this case. It is only because you did move her that the medical examiner saw the fixed lividity on her left side and her back when the autopsy was done. This fact was the whole case. Lividity made everything Nicolas said a bold-faced lie. We learned from an unimpeachable source that the defense did not spot the significance of Dr. Schutz's finding before we raised the issue in open court. We wish we had been flies on the wall of Carden's office after court that day. Did the Scream team scream? How is it possible to repay someone for caring, for being a decent human being? We do not know the answer to that. We just know that we owe you big time. Sincerely, Sharon A.H. May, Deputy State's Attorney.
And Roberta G. Siskind, Assistant State's Attorney.
That was a letter from the prosecuting attorneys to Officer Hannah, thanking him for breaking protocol. I'm going to dissect it a little bit. They say, the basic rule is you should not disturb the crime scene. We think the basic rule is a good one and should be followed. I agree with that. How about you? Then they say, we want you to know that although moving her was not standard procedure, it turned out to be the right thing to do. Had you left her in the car, we would have never won this case. What does that mean to you? Because to me, it says, thank you for breaking protocol because it messed with the evidence and so we were able to manipulate it to win. They also say, it's only because you did move her that the medical examiner saw the fixed lividity on her left side and back when the autopsy was done. This fact was the whole case. lividity made everything Nicolas said a bold-faced lie. It didn't, though, because Dr. Shute was wrong. 8 to 12 hours, not 2. The prosecutor said one more thing that particularly stuck out to me. We learned from an unimpeachable source that the defense did not spot the significance of Dr. Schute's finding. I don't know what that means, but I would really like to know who the unimpeachable source was. The day that I talked with Howard, I brought the letter with me. I didn't realize he'd never seen it. I'm going to play his reaction. There are some pauses in the conversation that I didn't edit out. It was intentional. I wanted you to know what it was like to be there. There was a letter discovered that Sharon May sent to Officer Hannah, basically thanking him for moving the body, like violating protocol. And she said that they wouldn't have won without that, and that she found out from an unimpeachable source that the defense team didn't understand lividity.
I have no idea what the unimpeachable source would be.
I mean, I could show you if you want to see the letter.
I'd like to see that. That was her argument. Lividity made everything Nicolas said a bold-faced lie. We learned from an unimpeachable source.
Yeah, I was like, who's the unimpeachable source? I was thinking about the huddles. I was like, well, who's at the huddles? I can think.
We wish we had flies on the wall of Carter's office. I have no idea who the unimpeachable source would be, but I certainly agree with the analysis that we did not consider it to be as strong a piece of evidence as the state did.
They didn't ask the right questions. They didn't have an expert. The prosecutors were very effective. Those are all facts. I love Harry's razors. Before Harry's, there were so many razors in my shower and the little plastic caps stuck in the drain. Now, though, there's only my Harry's razor, the best one I've ever owned, and my shower is cleaner than ever. Harry's is so confident you're going to love their blades as much as I do, so they're giving you a free trial shave set when you sign up at harrys.com/convicted. You only have to pay for shipping. Harry's is all about a great shave at a fair price. It was created by Jeff and Andy, who are two ordinary guys. They were fed up with buying overpriced razors, so they started Harry's, and shaving has been forever changed. Claim your free trial offer from Harry's today. A $13 value for free when you sign up. You just cover shipping. Your free trial set includes a weighted ergonomic razor handle, 5 precision engineered blades with a lubricating strip and trimmer blade, rich slathering shave gel, and a travel blade cover. To get your free trial set, go to harrys.com/convicted right now. That's harrys.com/convicted. I don't know if you have the same feeling that I did after reading that letter, but I'm going to share with you a second document that I had in my hand in that same defining moment. It's another letter from the prosecutors. This one is to Dr. Shute.
Dear Dr. Shute, you probably heard that Richard Nicolas was convicted of first-degree murder and use of a handgun in a crime of violence. The jury was only out for 2 hours, which is a very short time considering that the trial lasted for 14 days. We are 100% certain that your testimony was the reason that this jury had no difficulty reaching this verdict. You were just too marvelous. Were it not for courtroom rules and professional decorum restrictions, we could have hugged you right after you testified. The only thing that we could do was kick each other in absolute delight under the trial table. We certainly could not have asked for better. Of course, you realize that your stellar performance in this trial has now forced you to testify equally as well in all subsequent cases. The Dr. Shute of the Nicolas matter is hard to follow. However, we know that you are up to it. Thank you, thank you, thank you. We are forever in your debt. Sincerely, Sharon A. H. May, Deputy State's Attorney.
And Roberta G. Siskind, Assistant State's Attorney.
As to the issue of lack of professionalism, I think this letter mostly speaks for itself. The one sentence I'm going to focus on is, "We are 100% certain that your testimony was the reason the jury had no difficulty reaching this verdict." Because that's probably true. But what is also true is the prosecution's manipulation of his testimony, their hypothetical situation. It also went a long way in achieving the conviction. So the facts that we've established from what I just talked about are: lividity doesn't fix until at least 8 to 12 hours. Even so, lividity alone is not an accurate indicator of the time of death. The defense didn't question the medical examiner about either one of those things. The defense didn't call their own expert witness. The prosecution believed they won the case based on lividity. The prosecution thanked a police officer for breaking protocol because it helped them win. The things we, or at least I, in my opinion, can infer are, this is messed up, and this is not justice. We're not done with lividity, though. But I'm going to fast forward you to the future a little bit, and to the office of Richard's post-conviction attorney, Rachel. Remember her? When Rachel got this case, she called Dr. Shute. Rachel's smart and well-spoken and professional. She followed the call with a letter. She confronted him with the facts, the same ones that we just talked about. I've also been told that during their phone conversation, she asked him about the stomach contents. To his credit, Dr. Shute replied with a letter. It's dated August 26, 2008, and it's addressed to Ms. Kamens.
My answer was directed to what I considered the minimum amount of time for the process of partial fixation to begin. Could it have been longer than this? Yes, in my opinion, that could have been longer than this because this is a process that evolves over hours. I do not recall this latter point having been addressed and or emphasized at trial, and perhaps it should have been on cross or redirect, or in final summary arguments. It should be noted, however, that some featured observed at the scene, such as rigor or calor mortis, do not seem to support a long post-mortem time interval.
I had to look up some of the words in the phrase, "do not seem to support a long post-mortem time interval." And basically what Dr. Shute was saying was, all of the facts put together do not support there being much time between when Asia died and when emergency personnel arrived. I don't know whether to call it a recantation or a clarification, but it's the opposite of what the jury heard at the trial. Dr. Shute himself also pointed out that no one ever pushed him on the timing between partial and fixed lividity. In the last part of his letter, he addressed the stomach contents.
You also asked if I might comment upon the stomach contents and whether I thought it was consistent with popcorn. It was described at that time as 100 millimeters of yellow-brown, partially digested vegetable material. I think that's consistent with popcorn.
Popcorn. Like a snack you might eat with your father at a movie. I use Stamps.com pretty much every day to send out my bills, to send out your swag, or to return those impulse buys from the internet. I can send things domestic or international. If you've ever gotten something in the mail from me, you've experienced Stamps.com. I mean, basically, Stamps.com brings all the services of the U.S. Postal Service right to your fingertips. It's like I have my own post office, with no wait, right on my desk. I use Stamps.com because I'm strapped for time, and it's so convenient. And right now, you too can enjoy the Stamps.com service with a special offer that includes a 4-week trial, plus postage, and a digital scale without long-term commitments. Go to Stamps.com, click on the microphone at the top of the homepage, and type in "convicted." That's Stamps.com, enter "convicted." Stamps.com. Never go to the post office again. I'm scared of guns, and I would prefer to have nothing to do with them. If I were a jury member, would that bias me against a gun collector? I don't know. I mean, I know a lot of people who own guns. I grew up in the country. My high school canceled classes the first day of hunting season because attendance was so low. The point I'm making is people have widely varying opinions on guns, and no one's opinions are right or wrong, but they do determine their biases. Let me remind you, No weapon was found in this case. Richard Nicolas was a gun collector, but none of his guns were the gun in question. Why did every gun he had ever owned need to be paraded in front of the jury if they weren't related to the case? If he'd collected stamps, would that have gone to the jury? To be completely honest, I didn't know what gunshot residue was before investigating this case. I feel fortunate that someone, who wishes not to be named, reached out to me on this subject. So thank you. That person introduced me to the Scientific Working Group on Gunshot Residue. Basically, it's the organization that sets the standards in the field of gunshot residue. All the information I'm sharing with you, use their guide as the source. When a particle sample is given to a GSR laboratory to analyze, there's 3 ways that they can classify the results: characteristic of, consistent with, or commonly associated with GSR. The classification is made by its elemental profile, the types of elements in the particles. If particles are characteristic of GSR, they pretty much have particles that are only consistent with GSR, and it's unlikely that it could be anything else. If particles are consistent with GSR, they have some of the elements of GSR, but also have elements that are relatively common in our environment from things that have nothing to do with guns. Particles that are classified as commonly associated with GSR are made up of elements that are commonly found in environmental sources, but also have one of the other classifications. The 10 particles found on Richard's hand had 2 of the 3 elements of gunshot residue, barium and antimony. That would make it consistent with GSR. That would also make it consistent with brake pads, airbags, copy machines, nail guns, tasers, and a lot of other things. To the jury, particles were presented as gunshot residue. But the fact is, there's no way to know what actually produced those particles. I looked into antimony and barium themselves and what everyday products they might be used in. I discovered that antimony is used in printer ink, and barium is used in photo paper to make the pictures brighter. I can't draw any conclusions from that because I don't know, but they sound like things that might be present in a photo booth that prints instant pictures. If you're a true crime podcast enthusiast, you probably know what a Brady violation is. I mean, I remember the first time I heard Colin Miller explain it on the early days of Undisclosed. Just in case my mom's listening, though, I'm going to explain this one a little bit. The short version is, a Brady violation is when the prosecution has evidence that's favorable to the defendant. Not just favorable, but could impact the outcome of the entire case, but then they don't share it with the defense. The reason it's called Brady is because of a case, ironically in Maryland, where 2 men were convicted of murder. The thing is, one of the men took the blame. He made the statement that he did it, and the other guy, Brady, didn't help. No one told Brady, though, or his defense counsel, and both men were sentenced to death. The Supreme Court decided that was not okay, and that's how the Brady violation came to be. Do you remember when I told you about the witnesses that corroborated Richard's timeline on the night Asia was murdered? The ones that were at a hotel across from Bully's Lane? You don't? It's okay. The jury doesn't either, because that information wasn't disclosed. Let me tell you more. When I was on Bully's Lane, looking straight across from the spot we were parked was a hotel. It's currently something else, but at the time of Asia's death, it was a Holiday Inn. On July 27, 1996, the day after Asia's murder, Detective Gordon and Detective Massey went to that hotel. I know this because I have the police report signed by those 2 detectives. The report says that the detectives responded to and then the address of the hotel. I don't know if that means she called them or someone called them, but for whatever reason, they went. They talked to a person we're going to call Mackenzie, and she told them that the previous night at around 10 p.m., she heard a loud popping sound consistent with a gunshot. Right, that sounds like something important to me too. Something worth investigating. July 27th, the day Richard was arrested, the police had interviewed a witness who had heard a gunshot at the same time he said that someone had shot his daughter. I thought that was the end of it. They had just ignored the witness and moved on, until I found another document. It was a subpoena to the Holiday Inn for information relating to Mackenzie and another name I wasn't familiar with, Benson. This subpoena was dated September 23rd, 1996. That's 2 months after Richard had already been arrested and was sitting in jail waiting for his trial. Again, I was curious, but I didn't think anything had come of it because it would have, of course, been in the thousands of pages of trial transcripts that I read. That was wrong, because the next document in the saga that I found was dated January 23rd, 1997, 6 months after Richard Nicolas was arrested for the murder of his daughter. 6 months later, police talked to Benson.
Good evening. Today's date is January 23rd, 1997. The time is now 22:35. I'm Detective Gordon, along with Mr. Benson. Mr. Benson, can you please state your name, address, date of birth for me, please?
That's Detective Gordon. He and Detective Massey worked together on this case.
Mr. Benson, I'd like to recall your memory back to the 26th of July, 1996. You were staying in a hotel, is that correct?
Yes.
And the name of the hotel is?
Holiday Inn.
Benson heard the popping noise also. We're going to talk about Benson and Mackenzie much more in the next few episodes when we cover the appeals. I want to process for a second, though. I want to talk it out. First of all, I don't understand the timeline. The police didn't investigate on the night of Asia's murder. They didn't look for witnesses. The next day, they both arrested Richard Nicolas and talked to a potential witness. Then, 2 months later, they served a subpoena on the hotel where that witness was staying. Eventually, in January, they called another witness in for questioning. And then that's the end. What purpose did that serve? What am I missing? Beyond my frustration at my own lack of comprehension of the motives of the Baltimore Police Department, let's talk about Brady. All of these documents were in the police file. The police had seen them, and the prosecutors had seen them. But you know who never saw them? The defense. And ultimately, the jury.
I don't know what the facts are of this case. I am not the jury of this man's guilt or innocence. But I know a Brady violation when I see one, and this is pretty clearly a Brady violation.
Objectively, if 2 witnesses heard a sound that could have been a gunshot at the time that the defendant said a gun was shot, that information is not just favorable to the defense, but it could probably have impacted the outcome of the entire case.
But I know a Brady violation when I see one, and this is pretty clearly a Brady violation.
The jury came back in 2 hours and declared a man guilty based on lividity evidence that was misrepresented, based on particles presented as gunshot residue, but could have just as easily been residue from a copy machine, without the knowledge that 2 witnesses corroborated the defense's timeline. They didn't have reasonable doubt, but I hope now you can understand why I do. What do you do when you're in prison and then all this evidence comes to light after the fact? You appeal. You file post-convictions. But the thing about those are that they have nothing to do with innocence or guilt. Appeals are about proving that someone messed up, that the law wasn't followed. But when you're appealing with the label of convicted murderer.
It's the only thing that I have the utmost confidence in is that I'm an innocent man and that I can't stop fighting. Do I have confidence in the Maryland State court system? Absolutely not. I've got to continue this fight. First off, because of my daughter. First and foremost. Secondly, it's my well-being here is secondary to her. I've got to prove that I'm an innocent man. Through that process, I'm going to tell society that I'm not the only guy down here with half of the state of Maryland standing on top of his head and feeling hopeless.
Sometime next week, there will be a panel episode. The panelists include an attorney, 2 therapists, and a Q&A with Richard Nicolas. I think you'll find it interesting. I want to give a shout out to Vanessa from San Diego for one of my all-time favorite tweets. It said, "I appreciate the contents of your words, not the way they vibrate off my eardrums. Remember the fund for justice." I'm Brooke. Thanks for listening. You can see pictures, download the transcripts, and view other documents at convictedpod.com. I want to thank everyone who helped with this episode. Nina from Already Gone, Lainey from True Crime Fan Club, and TJ Cunahan from Pints and Puzzles. Convicted is hosted and produced by me, with music and scoring by musical genius Blake Maples. You can see and hear his work at blakemaples.com. We're going to take a short break for our first sponsor.
Hey guys, it's Lainey, host of the True Crime Fan Club podcast. If you're a true crime addict like I am, then my podcast is for you. It's a podcast for the ultimate true crime enthusiast, giving you a glimpse into the life and crimes of the most demented minds. You won't want to miss an episode.
I'm Nina Instead, host of the Already Gone podcast. Each week, I share stories of the missing, the mysterious, the murdered, and the lost. Stories that I share tend to focus on Michigan or the Great Lakes region, and they're stories you may not have heard before. I hope you'll join us.